Hello friends, can you file a writ for demolition or writ against demolition under Article 32 directly in the Supreme Court of India? The answer will be yes, my dear friends. There are a lot of people who have filed such kind of petitions against the bulldozer justice, which is called like a lot of people who are in whomsoever like the criminals they got involved in heinous crimes or gangsters or terrorists, such kind of people's homes are being razed away straight away. They've been getting demolished by bulldozers across the country in various states. So the Honorable Supreme Court of India has adjudicated two landmark judgments in the recent times. One is against the illegal constructions and against the bulldozer justice. The Honorable Supreme Court of India has came down very heavily, saying that you cannot, penalize the family for the actions of the whomsoever their family member. One family member might be a terrorist or a gangster or whomsoever, but you cannot penalize the entire family and demolish their homes without arbitrarily, without any notice or without following due process of law. And the Honorable Supreme Court has also gone to an extent of saying that whomsoever the municipal authorities or officers who will be resorting to such kind of misadventures will be penalized by contempt of court, as well as the money will be recovered from their salaries or their emoluments. So this is what is the stand of the Honorable Supreme Court of India. But my honest advice is nobody can directly go and knock the doors of Supreme Court under Article 32, because this is what is not just your fundamental right. It's like moreover your legal right and your constitutional right of right to property and following due process of law, right to equality, right to life and liberty, which covers Article 14, 21 as well as 300A as well. So in such kind of scenario, my dear friends, the Honorable Supreme Court of India directly does not entertain writ petitions under Article 32. They will always advise you to go to the High Court. So first you go to the High Courts and file an Article 226 writ petition, and if you do not get reliefs, you can always again file an appeal and writ appeal in the same High Court, which is known as intra-court appeal, in the very same High Court and before the division bench, and then you can knock the doors of the Supreme Court if you still have not got any reliefs. So this is what the due process of law is all about. One needs to follow this. Why? Because if you are filing such kind of petitions without going to High Court and directly in the Supreme Court, there is a problem that the Supreme Court might impose heavy penalties on you of almost 5 lakhs or up to 25 lakhs. So be careful.